Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, we are back in Calloway County with car wreck attorney Jeff Roberts. Jeff, how are you?
I'm doing good, Jim.
Buddy, we've talked about this in the past, but unfortunately, it's a topic that we really need to spend some time on again, and it's what to do if you've been involved in an accident with a drunk driver.
Yes. Unfortunately, these accidents continue to happen despite the public knowledge of how dangerous it is to be driving vehicles while you are under the influence of alcohol or any other intoxicating substance. People still do it, and unfortunately, some do it more than once, and they cause accidents when they do that. And so, during my career, I've represented several people who have been injured as a result of someone driving a vehicle drunk, whether they're in another vehicle or passenger in the vehicle with the drunk driver, not realizing or even maybe realizing, but no good option to do that, or chose to get in the vehicle anyway. But those are situations that unfortunately occur, and eventually, hopefully, people will learn not to get behind the wheel after they've been drinking. But I've seen some very smart individuals who make dumb decisions, and frankly, the more you drink, the more uninhibited you become. And even though when you go to the bar, you think, well, I'll never drink enough to get behind the wheel and drive drunk, some people later that night do exactly that. And so whenever that occurs, then there's different things that you need to do and that your attorney would need to do if you've been injured in a wreck.
And again, before we jump in, I always like to put this cautionary clarification ahead of time. Jeff does not defend drunk drivers. That is not what this is about. This is meant for someone who has been injured in an accident, in a collision that is involving a drunk driver.
Correct. In fact, I am still affiliated with the county attorney's office. As you know, I do child neglect and child abuse cases, prosecute those in family court for the county attorney's office. Because of that, I'm ethically prohibited from representing anyone, defending anyone in a criminal action, DUI or otherwise, from that standpoint. So I'm talking about people who've been injured as a result of a drunk driver. First thing is, frankly, you still have to establish negligence. Just because someone is behind the wheel intoxicated does not necessarily mean that they are the reason the wreck happened. You still have to prove negligence on the behalf of the drunk driver. Most of the time it's kind of obvious, but if somebody is over the legal limit and they're stopped at a stop sign and a car plows into them, or stopped at a stoplight waiting for it to turn green and the car plows into the back end of them, well, the drunk driver didn't do anything to cause that wreck. So, it's whatever driver's at fault. Most of the time it is the driver who's intoxicated, at least, are partially or the majority, if not solely, at fault in causing the collision. And some of the things that you need to do are the same as what you would do in any other whenever you're injured in any collision. From that, obviously, if you've been injured, then seek medical treatment. If the officer tells you or officer asks you, are you injured, even if you're just stiff at that point in time and you don't think you need medical treatment, let the officer know, I am hurting or I am stiff. My neck's very stiff right now, but may not go to the emergency room now, but if it continues, I may have it seen about. The best thing to do is go ahead and get it seen about right then, but I understand some people don't want to do that.
Well, and at the same time, your adrenaline could be going, and it could mask the pain that you should be feeling at the time. You're just not.
That happens frequently in a collision. Is the adrenaline is pumping, and you don't realize that you are injured. And frankly, I can speak to that from personal experience from one that I had several years ago, where elderly gentleman unfortunately pulled out in front of me and T-boned his dually pickup truck, and right after the collision. Frankly, I was more concerned about the elderly gentleman. My adrenaline was pumping. Luckily, I had airbags and had my seatbelt on. I wasn't seriously hurt, but my car was totaled. Had somebody that brought me back to the office and I was here at the office. And about an hour later, after all my adrenaline had gone out, my neck was hurting, it was stiff and everything, and I ended up going to the emergency room then. So, yes, that occurs frequently, and if that occurs, go to the emergency room whenever it starts, or urgent care, whatever facility you prefer to go to, and let them know you were involved in a wreck earlier that day or a day or two before, and that it's progressed since then. If that's the truth. Let them know, though, that that's the instigating event. Take photographs at the scene as well if you're able to do so. If the person gets out and a bunch of beer cans fall out of the vehicle, try to get a photograph of all of those. Make sure the police are called, and cooperate with the police when they get there. From that standpoint, with a DUI, when somebody wrecks into you that is intoxicated, though I think it's even, especially if you have very serious injuries, it is even more imperative to get in touch with an attorney sooner rather than later. Because, even though the accident may be very clear what happened, and who was at fault in the accident, and you have serious injuries, one of the things that needs to be done real early is that the officer very well may not do is to try to find out where the person became intoxicated, because as we've discussed before in car wrecks. Frequently, you can pursue the claim against the at-fault driver up to their limits of liability coverage. You may have and should have underinsured motorist coverage on your own vehicle, but if you have serious injuries, that may not cover all your medical bills, much less all your damages from that standpoint. And so if the driver had been at a restaurant and they served him, if they served him 8 drinks in 2 hours and then let him get behind the wheel and drive away, then that restaurant or that bar also has liability in this situation. And so to track down who that is, where he was at, and to try to establish, find out if there is a business entity or someone else that may be liable for the collision and for your injuries, then you need to know that early on, because the records at these facilities are going to be overwritten at a period of time. And so getting involved, getting that very early on, finding that information out can make a huge difference on whether you get compensated for all of your damages or if you're limited to what the car insurance limits are.
Well, it's interesting you bring that up, because I think a lot of people are hesitant to file a lawsuit. Well, it may not have been the restaurant or the bar's problem, and maybe I just have some emotional difficulty wanting to go after them, until it happens to you. And then suddenly let's say, as you kind of built the scenario, you've got significant injuries. Maybe you've got surgeries, maybe you've got lost wages, maybe you've got a lot of other expenses there where you could be up in the $100,000, $200,000, $300,000 level of medical bills, and the guy who hit you maybe wasn't insured or only had $25,000, which is the state minimum. Do you want to talk about it? I know you said there's the uninsured motorist, but these things come in play, and being able to make that connection suddenly becomes very important.
Right, and doing with the in these wrecks frequently, especially someone who's had other DUIs. They become difficult to insure. And so what happens is they get to high risk, and in those situations, they have very low limits. A lot of times it's 25,000, the least limits they can ride in Kentucky. So, if they have only 25,000 of coverage, and technically you can go against the personal assets potentially in the case, but most of the time the people are judgment proof. There's no assets to go against in that regard. And again, you may have on the vehicle you're in or on your own insurance underinsured motorist that will pay you over and above the liability limits. But even then, if you got 25,000 of liability and you've got good insurance, you've got 100,000 of underinsured motorist coverage, which is for Western Kentucky.
That's a lot.
Yeah, that's a lot for most people in Western Kentucky. So you've got 125,000. Well, if you have a serious injury and you're life flighted from Murray or from Hopkinsville to Nashville to get treatment because of the severity of your injuries, that flight is 60 plus thousand most of the time.
Yeah, just the flight alone.
Just the flight alone. That's not talking about the Vanderbilt or the TriStar medicals bills from that standpoint. Frequently, when I have clients who have serious injuries that are life flighted down, the medical bills in and of themselves are in excess of $300,000. So, in those situations, the insurance company, the insurance coverage car insurance coverage may not be sufficient to cover even the medical bills. And so if you have an attorney that knows what they're doing, they're looking at all avenues of recovery so that you can, my goal, and I represent someone, is to get the best recovery that I can obtain for them based on all the factors of their case in that regard. And so, but I don't pursue any claim that the client doesn't want me to pursue. So we'll have that conversation. But if I can establish that Joe's Bar and Grill overserved this person and then said, "Look, you're too drunk. We're not serving you anymore," and let him walk out and get behind the wheel of a car and drive out of that parking lot and then have a wreck a mile down the road, well, then the insurance on Joe's Bar and Grill should be paying your damages because Joe's Bar and Grill is culpable in causing this collision. They should have knew, not should have known, they knew. Everybody knows if you let a drunk get behind the wheel, then wrecks are likely to occur. So they should have known and did know not to let that person get behind that wheel, and they shouldn't have overserved them to start with. But certainly once that happened, said, "Okay, you're not leaving. We'll call you a cab. We'll call you an Uber. If you got a friend that can come pick you up, fine. But you're not going to drive out of our parking lot because you're too intoxicated to do so." And so, if somebody in Kentucky, as we've talked about before, Kentucky is pure comparative. And so if the bar is at fault in causing it, then they should be. I'm a big personal responsibility person. If I am responsible for causing somebody injury, then I should be responsible for paying the damages that I caused. If a bar or a business is responsible for causing somebody's injury, then that bar or business should be responsible for paying the damages that they caused.
Even if it's just a portion of the overall, but
Correct.
again, they had some, as
Correct.
you said, culpability in this situation.
Exactly.
Jeff, before we wrap up today's episode, let's talk a little bit. We've come at this from, okay, I'm driving down the street and a drunk driver hits me. But what happens if I'm a passenger in the car driven by the drunk driver, the intoxicated driver, the person driving under the influence? How does that change? What kind of rights might I have?
Well, you still have the same rights from the standpoint of the liability insurance and all of that. Now, what comes into play, as I mentioned earlier, pure comparative. Well, if you knowingly get in the vehicle with someone who is intoxicated and you let them and get in there and ride with them, then the jury can apportion some fault to you in that regard as well and say, well, you're 10%, 15%, 25% responsible for your own injuries because you knowingly got into the vehicle with an intoxicated driver. And
Your legal liability doesn't extend to the people who were injured in the crash. That we're just talking about you decided to get into a dangerous situation, so you have some
yes,
exposure there.
Exactly. You were comparatively at fault in causing your own injuries. You're not responsible for anybody else injured by the drunk driver, but because you chose to get in that vehicle with the drunk driver, then the jury can say, okay, you're partially responsible for your own injuries, and if that's the case, you don't recover those damages. So if the jury says you're 10% responsible for your own injuries, then you only get compensated for the other 90% of your damages in that situation. So those factors come into play. I think when we talked about Kentucky being pure comparative, I mentioned the seatbelt there. If you fail to wear your seatbelt, the jury can look at that and say that's partially responsible for your injuries, and so you don't recover all of your damages because of whatever percentage you were at fault in causing those injuries. The same applies here. And again, you have to look at all the factors. It could be that the passenger was intoxicated as well, and okay, did they know the person was drunk? And it could come back again to the bar, not letting both of them leave and get when they knew both of them were too intoxicated to be anywhere near a vehicle, driving a vehicle at that point, or should not be riding with somebody that's intoxicated. So a variety, you have to look at all the factors, and there's a myriad of factors that come into play in every situation there. But the fact that you got in the vehicle with a drunk driver does not automatically say, okay, you can no longer recover for your injuries, but it certainly can reduce what you recover for your own comparative fault.
And I remember quite some time ago, we did an episode talking about PIP coverage for passengers. We were talking about the passengers' rights. Those would still apply, correct?
Yes, PIP would apply, to
You want to
everybody.
explain a little bit about what PIP is, by the way?
Yes, PIP is often you hear it referred to by a variety of terms. PIP, no-fault benefits, basic reparations benefits, all different terms for the exact same thing. Whenever you're involved in a collision, if you're injured, the vehicle you're in at the time pays the first $10,000 minimum. You can purchase added benefits, but the minimum coverage is $10,000. Pays the first $10,000 of your medical bills and/or lost wages, and some other things that could come into play. But generally, that's what you see it used for. Primarily, is medical bills and lost wages. There, so and the vehicle you're in pays that initially. And then later on, the at-fault driver's insurance will reimburse all the other car insurances for the PIP that they've had to pay out in that regard. So if you're in a different vehicle from the drunk driver, your insurance is going to pay for that first $10,000 of medical and/or lost wages, and then your insurance will get reimbursed from the drunk driver's insurance later on down the road. And everybody in the vehicle has their own $10,000. It's not $10,000 split between everybody. If you're a passenger in the drunk driver's vehicle, fault doesn't come into play on PIP. So you've got $10,000 for your medical and/or lost wages. In fact, the drunk driver themselves have $10,000 of PIP coverage. So if the drunk driver gets hurt, then their medical bills would be covered up to $10,000 by their own car insurance, by the PIP coverage on their own car insurance.
And that's why it's so often referred to as no-fault benefits, right?
Correct.
It's not a question of negligence.
It's not a question of negligence. And you frequently hear Kentucky referred to as a no-fault state. That's really the only part of the Kentucky law that is no-fault, is the PIP benefits part of it. And that's the reason it's referred to as no-fault benefits,
Right.
yes.
So again, if I'm driving down the street and I get T-boned by a drunk driver, I also have the PIP benefit. It's not just the passengers of that car. It's basically everybody, right?
Everybody, but it's the car you're in at
Correct.
the time, or if you're a pedestrian, the car that makes contact with you. So that's always struck me as somewhat odd. So if you're standing on the sidewalk and a drunk driver hits a parked car, knocks that parked car into you, The parked car's PIP is the one that pays
Wow.
for your PIP. That pays your PIP and then gets reimbursed from the other one. But it's the vehicle that makes contact for a pedestrian.
Okay. Once again, be careful on the sidewalks, ladies
Yes.
and gentlemen. Be very careful on the sidewalks.
Now, and since we've talked about PIP, motorcycles, PIP is not required for motorcycles. It is optional. You can purchase PIP, but it's not required coverage. It's not mandatory coverage in Kentucky for a motorcycle. So if you're on a motorcycle, you may not have PIP coverage. You need to make sure, and if you don't have it, you need to get it.
Right. And friends, each spring we make a point of doing a sort of a public service announcement. Jeff's been an avid motorcyclist for many, many years. And, so each spring we kind of do a motorcycle accident related episode, and that's going to be coming up here soon, probably the next couple of months. And I just I'll put some links down in that. But yeah, that's a big loophole that I think a lot of motorcyclists really are not necessarily aware of, or maybe they're confused about. And it's that's $10,000 worth of injuries that they're just out most of the time.
Yes, because Kentucky law is that if you do not have that coverage, if you don't purchase it on a motorcycle, then you lose the first $10,000 of your medical or lost wages. You cannot recover that from the at-fault driver in that setting. So it can be very it can make a huge impact on the recovery because you lose $10,000 of your claim like that.
Right. So, Jeff, I mean, as we talk about coming back to the drunk drivers, I mean, obviously there's probably going to be, when the police officer shows up, hopefully he or she will notice, hey, wait a minute, something's not right with this driver. They seem to be intoxicated, and suddenly, the criminal side comes into play.
Correct.
How does that interfere at all with your personal injury claim, with your injury claim from the drunk driver?
It does not interfere with it. It is something that you want to monitor. Because if they plead guilty to it, or if they're found guilty, that I think can have a big impact on the car wreck case. Frequently, if they're charged, most of the time the insurance company's not going to fight that often. If it is someone who happens to have really high liability insurance, and a question of whether your damages are going to exceed that or not, then they may try to fight that case. You hear punitive damages discussed, and certainly punitive damages would be applicable in these type of cases. But an attorney has to make a educated decision on whether they want to pursue those if they litigate the claim, because punitive damages generally aren't covered by insurance. So you may not want to make that claim and have the jury award a large punitive that you can't actually recover. So, but most of the time, if it's a DUI case, the insurance company is smart enough not to fight the fault aspect of it. But occasionally they will, especially if it's real high damages and they've got high liability coverage as well. But it's still something, even otherwise, I think the attorney needs to keep an eye on what's taking place in that criminal prosecution, because that can have a huge, can have an impact on the case.
Yeah, I would think just from the sequencing of it, if I were driving drunk, and I don't want to admit something in the injury case that could be used against me in the criminal case, so I would think that kind of slows it down just a little bit in terms of just getting the ball rolling or getting the case completed.
It does frequently, and that's one of the things that can come in to be a problem, is trying to get the information about where they obtained the alcohol and where they did their drinking. And, you can work with if they've got an attorney in the criminal case, then, you can kind of work back channel, so to speak, with the criminal defense attorney and say, look, I understand they may want to fight this. I'm just trying to figure out so I can get records and double check this. They're probably going to be a little hesitant unless they know they're going to end up entering into some sort of a guilty plea on sharing that information. But you can, and that creates some problems down the road in trying to gather who all they were where all they were at and who all served them for those cases against the bar or the other. I know there's been some talk of changing the law in Kentucky to extend the statute of limitations in these type of cases for until after the criminal prosecution is over with, because statute of limitations against a bar that overserves is 1 year from the date the wreck occurred. And so, if the criminal prosecution takes longer than that, you may not know who did the overserving, because the person's not going to talk because of their Fifth Amendment right against self-incrimination, and the criminal defense attorney doesn't want to share that because it can be used against the person as well. And so, like I said, there's been, unfortunately, it hadn't passed in Kentucky yet, but there's been some talk about extending that for that very reason, is to protect those potential claims that may be out there. And so, but that's part of the reason, the earlier an attorney is involved, the earlier they can go investigate those type of things and find out. And if you can get that early on, then that helps out in pursuing these claims.
That's a factor I'd never really considered, is the fact that the clock could run out on your injury claim because the criminal claim is going on, and that once that statute of limitation expires, you're kind of out in the wind.
It doesn't.
Yeah,
you don't get it back.
No, not really. Friends, I'll put a link to. We did a specific episode on the statute of limitation and why that's so important. So again, from a clarification standpoint, if you want more information on it, click on that link. You can find it on the website as well. But I'll make sure that that's available to you as well. Jeff, you've handled car wreck cases. I mean, again, as an attorney licensed in the state of Kentucky, while you have 2 offices in Western Kentucky, you can handle these cases pretty much all over the state.
I can, and I do handle car wreck and workers' compensation claims all over the state from that standpoint. So, yeah, I do have the 2 offices. I have my main office in Murray, Kentucky. I have a satellite office in Hopkinsville, Kentucky, but I represent clients all over. I've got several clients up in the Bowling Green area, in the Louisville area, Lexington area. That standpoint.
You've had cases up in northern Kentucky?
I've had car wreck cases out in northern Kentucky, over in eastern Kentucky. From there, and especially with the advent of the video communication through computers and obviously FaceTime on phone, but with Zoom and Microsoft Teams and some of these other video communications, it makes it easier to represent folks in other locations from there. But the best way to reach me is by phone. I have one phone number, so you can reach me at that. You don't have to try to get phone numbers to figure out which office I'm at on that day. So the way to reach me is 270-753-0053. If you're out of the area and want to use an 800 number, it's 1-800-844-5108. And you can reach me by, if you call during business hours, you're going to have a live person answer the phone most of the time, unless we're tied up on all the other lines from there. But if you've been involved in a car wreck, if it's with someone who was drunk or not, if you've been involved in a car wreck and you have some questions about that, please feel free to give me a call.
Outstanding. Jeff, I really appreciate your time. And friends, as you're listening to this, I want you to remember something. Jeff's done this for 32 years. He's been down in Murray and all over Western Kentucky doing a lot of these cases. And so he's got a certain level of experience. And if you like to learn a little bit more about that, check out his Google reviews for the Murray office, where as someone who's now a solo practitioner, meaning he's the only attorney in the office, you look at the number of positive 5-star reviews that he has. I mean, it's absolutely incredible. And that's, I think, a testament to the quality of work he does. And in fact, here at the office, Jeff, you have a motto that you'd like to talk about.
Yes, my motto for the office, not only for myself but for everybody in the office, is for us to that we provide small town service and deliver big city results, and we strive to live up to that motto in every one of our cases.
Outstanding. Well, Jeff, we'll be back in about 2 weeks, and then we'll get ready to prep up for the motorcycle tips that are coming out here in the springtime. So I hope if you're a motorcyclist and you're listening to this, be sure to follow up, and we'll have that episode out shortly. So, Jeff, thanks again for your time, guy.
Thank you.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.